In this session, we're going to study products liability. So what is products liability? When we say products liability, we're referring to the legal liability that a business may have for goods that it either manufactures or sells, provided that those goods are either defective or they're dangerous and they cause harm or injury to either the buyer, the user of the product, or perhaps an innocent bystander. It could also cause damage to property. So products liability is the broad term that's given to essentially to cover harm that occurs through products that are sold that are either dangerous or defective. So in a products liability claim, the plaintiff, that would be either the user, the buyer, or an innocent bystander or somebody whose property was damaged, they would be the plaintiff. That person is generally required to show that the business sold the product in either a defective or a dangerous condition, and that that condition was the cause of the injury, either to the person or to the property. It goes back to how we just talked about negligence in the last session. Negligence, we talked about one of the key elements is causation. You've got to be able to show that the defective or dangerous product has a connection to the injury, because it would not be fair to hold somebody liable for just an injury to happen only because the product exists. There's got to be some dangerous or defective condition that is connected to the injury. So in products liability, there are three main theories of recovery, and the book looks at these briefly. One, you have a breach of warranty, and this goes back to our cells chapter. If you remember us discussing cells in week 3, that UCC Article 2 has in it concepts of express and implied warranties. Express warranties are those that are expressly told to you by the seller or the manufacturer. The implied warranty, you have the implied warranty of merchantability and fitness for a particular purpose. Those may be implied by the UCC provisions. So we're talking about a breach of warranty for a product's liability claim. You're looking at whether the quality or the characteristics with the product that you got are consistent with what you were told either in the express or the implied warranty. And if there is a difference there, you may have a claim for a breach of warranty. So as an example, if you have a manufacturer of an engine and they tell you this engine will go problem-free for 100,000 miles, and the engine starts having problems at 30,000 miles, you may have a claim for a breach of warranty if they don't fix it. You know, the warranty, the remedy through that is they can either repair it or replace it. And if they take care of it and they either replace it or they repair it, they're not going to breach their warranty. But if it does not do what they told you it would do, if the product here, the engine, doesn't do the 100,000 miles like they told you, then you may have a breach of warranty claim if the warranty is not taken care of through replacement or repair. The next type of theory is the negligence theory. The negligence theory is where the injured party must show that the manufacturer or seller did not use reasonable care when they designed or they manufactured the product, or that they failed to use reasonable care in providing a proper warning. The negligence theory is available, but it's a difficult one to prove, and it's often not used. The prevailing theory is the last one here, called strict liability. And you'll recall when we discussed negligence and strict liability, when we covered those topics, that strict liability means that you are held liable irrespective of how careful you were or how much safety and precaution you took in performing an action. Well, the same carries over in here, in that no matter how careful you were in designing the product, no matter how many steps you took, that if it was still dangerous or defective, you may be held strictly liable for the injuries that's caused by the product. So the strict liability, we're going to look at that mainly that'll be the topic we look at for the product's liability only because it's the prevailing standard. So let's look at strict liability. Strict liability is essentially a public policy decision, and it's based on principles of fairness and equity, in that the manufacturer or seller is the party in the transaction that's in the best position to bear the risks. The textbook does a good job of examining the underlying reasoning for strict liability in products liability. First, the law is designed to protect consumers against unsafe products. Public policy favors the sale of goods that are safe, products that are not going to harm you or injure you or your property. Second, they look at the cost of the injury should be borne by the party that's best able to prevent, detect, eliminate, and insure against the defects or the dangerous condition. And so, obviously, the manufacturer and seller are the parties who are in the best position to be able to prevent and eliminate and insure against products being defective or dangerous. And so, by having the potential liability, a manufacturer or seller is encouraged to make sure that they design the product properly and that it's manufactured properly. The third rationale is that imposing strict liability will encourage manufacturers to go the extra mile to produce safer products and to improve existing products. That kind of merges with what I was saying at the end of discussing the second one, in that it encourages them, as the manufacturer and seller, to do everything they can to avoid the potential consequences of a product's liability lawsuit, to avoid having to pay a user or innocent bystander or the buyer for the damage and the harm that they suffer because of a defective or dangerous product. And it goes even further, because if one is defective, if it's a defective design, or even if it's defective in the manufacturing, which we'll talk about the distinction between those two in a few slides, but even if you're looking at those, it's likely that it's not going to be an isolated incident. And so if you have a wrong manufacturer process that happens and you've got some bad parts that are used that are imperfect and that are causing injuries, in that batch, there may be 100 of those that could fail, or there could be 5,000. If it's a design defect that makes it dangerous, then the entire product line would be bad. So there is the potential in a product's liability case to have a large number of claims. You could have a class action lawsuit in the product's liability area. And so for that reason, manufacturers and sellers are encouraged to do everything they can to protect against dangerous and defective products. And the last reason is that the law gives sellers an incentive to deal with reputable manufacturers. So if you look at the sellers and the manufacturers, and a manufacturer may also be a seller, but a lot of times you have somebody that manufactures goods, and then somebody like Walmart is the seller because they put it in their stores, and that's where us as the consumer can go and buy it. And so you want the seller to work with people that are manufacturers that have good reputations. Walmart's not going to be stocking products in their store from manufacturers that have a known problem with design defects or poor use of materials. So what this really gets down to is that you're looking at who is in the best spot to bear the potential risk and to protect against those risks. So again, it goes back to fairness and equity. So the manufacturer and seller, being in the best spot to protect against those, they're the one, and can also are in the best spot to pass along those costs. So it's not in the sense that you're imposing some huge burden on the manufacturer and seller, because any additional cost that it creates, they can pass on ultimately to the consumer. And so a product may cost $20 more, but that's also means that it may have been a safer, less defective, less chance of it being a defective product. So manufacturers can ultimately pass along the cost that it takes to avoid, that's them being proactive to prevent there being a defective or dangerous condition of the product. And they can also pass along the ultimate cost, if they have any, when they do incur products liability claims. So let's look at some of the requirements on a strict liability uh, claim for product liability. So under the strict liability, these next few slides, we're going to look at what Tennessee law requires to establish strict liability on a defective or dangerous product. So under Tennessee law, manufacturers or a seller is liable if the product is, quote, in a defective condition or unreasonably dangerous at the time it left control of the manufacturer or seller. So it's important to note here that last phrase in that it's got to be dangerous or defective at the time it left the manufacturer or seller. So if a product, something subsequent happens to the product, if there's a change or an alteration, and we'll talk a little bit more about this later, then it may not, and that change or alteration makes it defective or unreasonably dangerous. That change, alteration, is going to negate the liability of a manufacturer or seller because it has to be unreasonably dangerous or defective at the time it leaves the manufacturer or seller. So this is designed to limit the scope of a potential claim. It's got to be defective and it's got to be something that the manufacturer or seller is responsible for. Or if it's unreasonably dangerous, it's got to be something that the manufacturer or seller was responsible for. And that makes sense. You don't want manufacturers or sellers being responsible for things that happen to their products that may make them dangerous or may make them defective and cause injuries. The determination of whether a product is in a defective condition or is unreasonably dangerous, you base that determination on the state of the scientific and technological knowledge available to the manufacturer or seller at the time the product was placed in the market, as opposed to when the injury occurred, which could be several years later. So this again ties back into limiting the scope of a manufacturer or seller's liability. So if you talk about technology and how fast things change, if something that's produced today causes an injury a year from now, what's known about through the state of scientific and technological knowledge, what's known could be drastically different in a year from now than what it currently is. And so it would be unfair to hold manufacturer or seller to an expectation in today in 2025 for what they're at in say 2018. And so it puts a limit and it makes the manufacturer or seller not be liable because they didn't do something based on knowledge that's acquired after the product is manufactured. A product is defective if the condition of the product renders it unsafe for normal or anticipated handling or consumption. So it's defective essentially if it is unsafe for what it was expected to be used for. So if the use of the product, its anticipated or normal use, is such that you can't do it without it being safe, then the product would be in a defective condition. Similarly, a product is deemed unreasonably dangerous if the product is dangerous to an extent beyond that which would be contemplated by the ordinary consumer who purchases it with the ordinary knowledge common to the community as to its characteristics. Again, there's placing a limit on it of what ordinary knowledge an ordinary person would have in that spot. You're not talking about somebody that's an expert, but the ordinary everyday person. And so it's dangerous if the product would be dangerous if it has some dangerous characteristic to it beyond what the ordinary consumer expects, beyond what danger or harm is expected to be presented by it. Let's take an easy example. A gun. There's an expectation that a gun will have the dangerous or the harm that could happen with unsafe use of the gun. You could shoot and harm yourself or someone else. But that doesn't make the gun per se unreasonably dangerous such that you would have a product's liability case automatically. Now there could be characteristics of the gun that make it more dangerous. An example is if it was one that was designed or anticipated to be designed where if you dropped it, it would not fire, but there's some design problem to it and it does drop and it falls, and if it hits, it may fire on its own, then that could be an unreasonably dangerous product, because it's a danger. The danger being firing when dropped is a danger that's beyond what it was contemplated to have by the consumer, because the expectation and what was probably sold is that it's a safe gun, that if it drops, it's not going to fire. A product may also be unreasonably dangerous if, assuming the dangerous condition was known, a reasonably prudent manufacturer or seller would not put the product into the market. So let's go back. There's in the book, it talks about this example at some point, and I'm not sure if it's here or not, but they talk about Ford when they developed the car, the Pinto, where the gas tank was placed in the rear, and it was dangerous because if you hit, if there was an impact with another car there, there was a chance that it could hit the gas tank and cause an explosion. And so, knowing that potential dangerous condition, would a reasonably prudent manufacturer or seller place that Pinto into the market? If that was known, probably not. A prudent manufacturer or seller would recognize that as a substantial risk and not put the car into the market. For that reason, under that example, the product of the Pinto would be unreasonably dangerous, because assuming that condition was known, a reasonably prudent manufacturer or seller would not have placed the Pinto onto the market, because the danger of a car being exploding upon impact in the rear would be too great, such that a reasonable manufacturer would not put that out to the public. But as we kind of foreshadowed a few minutes ago, a manufacturer or seller is not liable if the product is made unreasonably dangerous by a subsequent unforeseeable alteration, change, improper maintenance, or abnormal use. So the product can't be altered and then try to blame the seller or manufacturer. You can't not properly maintain the product and something happened, and then blame the manufacturer or seller. You also can't use the product abnormally and then blame the manufacturer or seller. So let's go back to a gun. If you take the gun and you alter it and you're trying to make it from being, in the United States, it's illegal to own an automatic firearm. But if you're trying to convert the firearm to an automatic firearm and it blows up because you didn't do something right, you can't blame the manufacturer or seller of it, because you made a subsequent change to the gun. Similarly, if you have the gun and you don't ever clean it and you've shot tons of bullets through it, and maintenance requires you to clean it, and because you're not cleaning it, something backs up and you shoot, try to fire it and a bullet doesn't fire and it explodes in your hand, causing damage. Again, you can't blame the manufacturer or seller, because you failed to maintain that handgun properly, and that's what caused the product to become unreasonably dangerous and defective. Also, let's say you have a gun and you take it and you decide, when I was a kid growing up, people had potato guns, and decide, well, I'm going to turn this rifle into a potato gun, and you try to put a potato down in it and alter it, and you're trying to shoot potatoes through it. Obviously, the gun was never intended for you to shoot potatoes through. And so if an injury happens because of trying to shoot potatoes through a gun, that's going to be an abnormal use of that product. And this manufacturer or seller is not going to be liable for any damages or injuries that happen because of that abnormal use. So again, this places a limit. The manufacturer is only held, the seller is only held liable for injuries and damages that are connected to what they did. So you're not holding them liable for some bad act on your behalf. If you go back to our negligence principles, that's like the comparative fault defense. So this is limiting again, and it's all fairness and equity, and a manufacturer or seller shouldn't have to bear the cost of something that they didn't do. And so the abnormal use, the alterations, the improper maintenance are all things that the seller or manufacturer did not contribute to. So the manufacturer or seller is only liable for things that they did wrong in designing it and manufacturing it and warning. Under Tennessee law, a product is not deemed unreasonably dangerous because of a failure to warn of a danger or hazard that is apparent to the ordinary user. The example is one that we just gave a few slides ago, that a gun is not considered unreasonably dangerous because the manufacturer or seller did not warn the buyer about shooting oneself could be dangerous, that you could harm yourself if you shot yourself. That's a danger that is known and apparent to the ordinary user. And so the product, the gun, would not be deemed unreasonably dangerous because they didn't explicitly say there's a hazard here that you could shoot yourself and harm yourself. So a seller's liability, we've been talking about seller and manufacturer, there's a potential that a seller may have limited liability compared to a manufacturer. And that makes sense because if you think about it, who's the one we talk about? There could be design defects, there could be manufacturing defects. Well, a lot of times Walmart is not involved in designing or manufacturing a lot of the products that they sell. Rather, they're just an end supplier that is selling it to the public, to the consumer. And so, should the seller be subject to the same liability that the manufacturer is? So, if you have a razor that Walmart's selling for Norelco and there's something wrong with it and it causes it to overheat and burn your face, should Walmart be liable for that when all Walmart's done is order it, place it in the store for the consumer to buy? And to me, there seems like there's an equitable reason for Walmart to not be as liable in that situation as much as the manufacturer, because Walmart didn't design that razor, nor did they manufacture it. Norelco did. All Walmart did is bought it and put it on the shelf to sell. So a seller is not subject to liability if the product is acquired and sold in a sealed container. So in this instance, the razor would be in a sealed container, or when the product is acquired and sold by the seller under circumstances in which the seller has no reasonable opportunity to inspect the product such that it would discover the defective condition. So in the example of Walmart or Kroger, whatever store you want to think of, retail store, a lot of times they're selling goods that are in prepackaged boxes or bags, whatever, to where Walmart's not bringing them in, inspecting them, and looking at them to make sure that they're not dangerous or defective. So in those scenarios, so in the strict retail sense, Walmart was most likely not subject to liability in our Norelco example or in many other examples of things they sell. Now in store brands, if it's something that they do have more of a hand in designing or manufacturing and selling, then this exception is not going to apply, or this limitation is not going to apply. Also, this limitation may not apply if the manufacturer is either bankrupt or not subject to personal jurisdiction. So if the manufacturer makes something and they only make it in California, but somehow Walmart buys it out there and they ship it everywhere, Walmart would be the one that would likely be subject to the product liability claim then, because a court here in Tennessee would not likely have personal jurisdiction over this California company who makes it and sells it to Walmart in California. Also, if the manufacturer goes bankrupt, if Walmart's dealing with some company and the company goes bankrupt, then there's a chance that Walmart may be held liable for any product's liability claim. So let's talk, that was what we just went through. The last several slides, since I first mentioned it, have all been based on what Tennessee law is for a product's liability claim. So now we're going to talk in a general sense more of what the book says. But that Tennessee liability or product's liability law that we just went over is representative of what many states' law is. So when we say a product's liability, you think clearly, what's a product? Well, you would think most anything. And a product is just any tangible good or object that's produced. So it's a very broad range of items that could qualify as a product. So you see that there's a lot of things that may have products liability lawsuits. Now, it excludes services and it excludes intangibles. And you think it would be clear, well, what's a service and what's a product? But like the book notes, there are some gray areas. One example that it gives is if you're um, having a dentist who's using a needle and they injure you, is their needle, or is it the service that injures you, or is it the needle, the product? Same thing as they use a hair solution by a hairdresser that causes an injury. So are they performing a service by using the solution on your hair, or is it the product? So it's not always a bright lined area of, oh, this is a product or is this a service? Um, Also, the book talks about software and fixtures, how those can be gray areas of what is a product. But by and large, most things that you think of that you would buy that would ring in your mind as, hey, this may be a product's liability issue, are going to be goods and products that you would typically think of are going to qualify. Now let's look at some ways that a product is actually deemed defective. How could a product be defective? We have already talked a little bit about some of these in going through our examples, but let's kind of hash them out. So you have a manufacturing defect. It means exactly like what you would expect it to mean based on the title. There is some flaw in the product when it's being produced. So you have a manufacturer, they're manufacturing, let's say they're manufacturing, we've used guns throughout this, let's say they're manufacturing a gun. So it's a gun manufacturer, they're making something. Well, uh, there's a series of parts that they've gotten that say they're a steel pen and the pen is bad. It's not, it's got a impurity in its qualities of, if it's the impurity causes it to not be strong. Let's say that. And so got a weak pin, and that weak pin goes in, but nobody knows it. It's produced. It then goes out to the consumer. The consumer starts using it, and the product breaks, causing injuries to a hand, say. And that would be a manufacturing defect because there's not something wrong with the design of the product. It was a flaw that happened when it was being produced, and the flaw was that they used impure materials. So the pen didn't have the strength that it needed for uh, the use that it was intended for. And so that's a flaw in the product when it's being produced. And these defects are usually unique to a few individual units or a series of units. And so in the example here, it would only be the guns that got those impure pins. And so if they produce 10,000 of these guns, the impure pins may only be in 100 of them or a few hundred of them. And so this defect is often unique to either an individual unit if it's something that's real rare or custom made, or it may be a series of units to where it's not every product that's ever been made is defective. The next is you have a design defect. This is what you think of, the opposite where before we just talked about with the manufacturing, it may not be all of them. Well, in a design defect, usually the the product is defective from the beginning. And so the product has a problem in the design such that it makes it unusable and dangerous. So the product is being manufactured properly. We just talked about it being manufactured with an impure part. There's a flaw in the manufacturing. Here, you're manufacturing it properly, but there's a problem with the product. So you're following the design, the plans for it, but there's a problem in the plan or design. And as a result, the product is defective. So there are two approaches that are set forth, and the restatement second is one, and the restatement third is another. And the restatements are basically where lawyers and legal commentators got together and they worked out a general statement of the law. And there's a restatement on various principles. Some are torts, and there's also a restatement of contracts and other areas of the law. But have been multiple drafts of them. And so the restatement second, and then the restatement third, and the restatement third is the most recent draft. But they give a little different approaches on the design defects. So the restatement second uses what's called the consumer expectations test. And this is stated as the article sold must be dangerous to an extent beyond that which would be contemplated by the ordinary consumer who purchases it, with ordinary knowledge common to the community as to its characteristics. So this definition of the consumer expectations test should be real similar because it's very much almost the definition Tennessee law uses for when a product is considered unreasonably dangerous. So in Tennessee, they've more or less adopted the restatement second approach. But on this restatement second approach, they use what is known as a risk utility balancing test. And this is where a court will balance the product's risk with the product's utility to the user and public. So it's basically a risk benefit type analysis. And there are a number of factors that are used. And so obviously when the court take these in, you want the risk to the product to be outweighed by the utility of the product. The value, the benefit to the user and the public needs to outweigh the risks of the product, because if the product is more risky than the benefits it provides, then there's no real reason to use the product. Now, the factors, the book states them, and I've put them here on the next slide and this slide, and really they kind of speak for themselves, but we'll quickly go over them. Factors, the usefulness and desirability of the product. So how desirable is a product? What benefits or value does it provide? Second, the safety aspects of the product. What's the likelihood that it's going to cause injury or harm to somebody? So you're again trying to balance, find what's the value, what's its usefulness, versus what are the safety hazards of it. Is it a safe product? Is it not? Obviously, the more useful a product is, the more that weighs in favor of it not being defective. Same if it is a product that has little risk. If it's a relatively safe product, then it's more likely to not be a defective design. But if there are serious safety risks or potential harms or injuries as a consequence of the product, then the more likely there's a design defect. So continuing with the factors, the third factor is the availability of a substitute product that would basically meet the same needs and be safer. So is there an alternative out there? If there's an alternative out there, then it makes it that's safer and better, then it makes it more likely that the design is defective. Fourth, we look at the manufacturer's ability to eliminate the unsafe character of the product without affecting negatively the usefulness or the value of the product, and you also don't want it to become too expensive. So you may be able to eliminate the risk and preserve the usefulness or the value of it, but it may become too costly to do that. And so you're looking at to make sure that you do have the safest product here. Is there something that could have been done to eliminate the unsafe nature of the product? If there was, and it wasn't too costly, then that weighs in favor of it being a defective product, defective design. Next, you look at the user's ability to avoid danger through using the product carefully, exercising reasonable care. And so if the user has an ability to avoid harm, then that's more likely that it is not a defective product. It shows that it's more of a improper use of the product, or use with the lack of knowledge of how the product should be operated. The next one is the user's anticipated awareness of the dangers inherent in the product and the avoidability based on general public knowledge of the obvious condition of the product or because of suitable warnings or instructions. So was the harm here one that should have been anticipated by the user, either because of it's a danger inherent to the product and it's something that's generally known to the public, or it's so obvious that they should have known it, or if there were warnings. And so if there are adequate warnings of the potential danger, then it becomes less likely that it's a defective product. And the last factor is you look at the feasibility on the manufacturer's part of spreading the loss by setting the price of the product or carrying liability insurance. So this is you're looking at, could the manufacturer, what's the likelihood of them helping bear this risk or allocate the loss to them by carrying liability insurance to protect against the harm that could have happened, or by setting the price of the product high enough that it would have had sufficient funds to fight, or not necessarily fight, but I mean, part of it is litigation over these claims, but to be able to compensate people for the injuries and the harm that happens because of these defective products. So those are the 7 factors that you consider under the restatement second to determine if the design was defective. So the third restatement, and I told you it differs just a little bit, and the main difference here is that under the restatement third, they require that the plaintiff show that a reasonable alternative to design was or could have been available at the time of sale. So you basically got to, this goes to almost implying a negligence standard, because you have to show that there was a reasonable design alternative that was either available or reasonably could have been available at the time that this was manufactured and sold. And so you're saying essentially that there's something that they could have done better, but they failed to do it. And so this is, for that reason, a minority view, because it almost blurs the line between strict liability and negligence. So we talked about manufacturing defects. You've got defects in the design. You can also have liability because you have inadequate warnings, labels, or instructions. As you would probably expect, manufacturers and sellers have an obligation to provide warnings of the possible risks that could happen or that are foreseeable of the use of the product. So if you have a product that you buy, you open it up. A lot of times there's either, there's a sticker on the product, or you may have some papers at the very beginning, the first thing you see when you open it. But it's very common to get products and them have warnings on them where they're telling you, hey, caution, this product may be dangerous. Caution, this product could be flammable. Whatever the risk may be, you'll often see where a manufacturer or a seller provides warnings about the risks or harm that are reasonably foreseeable through the use of the product. And when we talk about them providing warnings, you'll note that it's limited to warnings that could exist through the foreseeable use of the product. So it's not every potential use of the product. You don't have to sit down and try to think of how is every single possible way that they could use this electric razor. How could a baby use it? How could, a child use it? How could a teenager use it? You don't have to sit down and think of all the various uses that potentially somebody could use the razor for. Rather, you've got to only warn against the risks and harms associated with the foreseeable, the reasonable uses of the product. So in these claims, if you have a claim for an adequate warning or a label or an instruction, the plaintiff has to show that the manufacturer or the seller failed to sufficiently warn of a particular risk that was either known or could have been known based on generally recognized and prevailing scientific and medical knowledge available at the time of manufacture and distribution. So again, this puts that link to it to limit the manufacturer's or seller's liability. So they're only liable based on what was known or could have been known based on the prevailing scientific, medical, technical knowledge available at the time of manufacture and distribution. Therefore, if they fail to warn about something that's learned 2 years down the road as a potential consequence or risk of a product, they don't have a duty, or they didn't inadequately warn about that because it wasn't known then. They're only liable, and they're only obligated to warn for known things that were known or could have been known based on the information available at the time of manufacture and distribution. And so we talked about inadequate warnings or labels, but didn't say a whole lot about inadequate instructions. And obviously, That's probably inherent and able to know what it means, but let's just briefly say an inadequate instruction is that you're expected to tell consumers how to use the product. And so if you have either no instructions or instructions that are too vague or confusing, they may be deemed inadequate to where someone is harmed through using the product because they didn't understand how to use it because you didn't provide proper instructions. And so that's why it's important to have proper instructions enclosed with the product to help them educate the user on how to properly use it. So if you go and you open up, say you buy your car manual, it's full of stuff of things not to do, things to be sure of how to use something. And so they give you instructions so that they protect themselves from these claims. So again, there's the restatement second and there's a restatement third. So they have a little different approaches. So with the restatement second, uh, the manufacturer seller must provide sufficient instructions about the product's safe use, just like we were talking about. They got to educate the user on how do I use this product properly such that I'm not going to have some risk of injury. So the provision of giving an adequate warning or label and instructions is not a defense to improperly designed or manufactured products. So we've just talked about products that were designed um, with a defect or that have a defect in manufacturing. The fact that you gave them instructions on how to use it and you warned them of possible risks that could happen through the foreseeable use of the product, that doesn't insulate you from uh, any of the design problems or the manufacturing problems. So if you give them all the warnings they need and all the instructions they need, that doesn't mean that you're okay on a design defect or a manufacturing defect. So for these inaccurate warning labels or instruction claims under the restatement second, the plaintiff must show that the seller or manufacturer, they failed to warn of the foreseeable and possible risk of use, and that failure was in fact the cause of their injury or their damages. So again, you got to have that connection because they failed to warn about something. If that failure is not what caused your injury, the manufacturer or seller is not going to be liable for your claim. There are some products that are deemed unavoidably unsafe products. These are products in which the utility of the product outweighs the risks. And although the utility will outweigh the risk, there is still substantial risk in these products. And so these products that have utility but significant risks with them are unavoidable unsafe products. These often, the best example is medication. You may have some serious side effects of medication, but the medication has some great benefits for you given your medical condition. And so in these cases, so in the medication context, um, if you give an adequate warning, that can serve as a defense on the product's liability claim. So basically, you can think of it in terms of, and we'll talk in a minute about defenses, but this is akin to the assumption of risk type defense that we talked about with negligence and intentional torts. Here, you're being warned of the possible consequences of the medicine. And so if you're being warned of those possible consequences and you're making a conscious decision of, well, the potential medical benefits of this medicine is enough for me to take the chance of those risks, why should a manufacturer or seller be held liable under those circumstances? They shouldn't. And that's why an adequate warning to give them knowledge to make an informed decision will absolve the manufacturer or seller of legal liability. So there won't be any liability for a product's liability claim if they've given an adequate warning on these unavoidable, unsafe products. So let's talk about the restatement third. How does the restatement third treat these inadequate warnings, labels, or instructions? They adopt the requirement that the risk must be foreseeable at the time of sale. The majority of states have adopted this. In my opinion, this wasn't a big change because under the initial thing, everything so far has been based on what's known at the time of manufacture and sell. And so the restatement third doesn't really change much, but it just makes it clear that um, the risk that you're warning about or that you're giving instructions, it has to be a risk that's foreseeable at the time of sale. So let's briefly talk about who all would be subject to a product's liability claim. Really, it's any party that's in the chain of distribution. Any party, I'm not saying that all parties are liable, but any party may be subject to a strict liability, products liability claim. So the common people in this chain are you have the product manufacturer, that's the one who actually manufactures the product. The product manufacturer is almost always going to be liable, no matter how remote their involvement is in the whole chain of distribution. They're always going to be the party who ultimately made this, and they're always going to have liability. So, but you could also have a parts manufacturer, and that's somebody who made parts and sent it in. So if you'll go back to our gun scenario where the gun was built and it had the pins that were made with impurities in them, and they weren't strong or tough enough to withstand the use of the gun, well, that's a part, and that maybe was made by some other manufacturer. And so that would be a parts manufacturer who they didn't build the whole gun, but they made a piece, a part that went into the gun. And so that parts manufacturer could have liability for the product. And so they could have liability. When I say product, it's pin, it's whatever they create. So if it's a car that's sold by Ford, but it's got Michelin tires on it, if there's a defect with the Michelin tires, Michelin could be liable for that. But Michelin would be liable if there was a problem with the seatbelt that was designed and built by either Ford or somebody else. They didn't manufacture and produce and provide that seatbelt. They only did the tires. And so a parts manufacturer is liable for its parts and is not liable for any design defect as long as the exception of that is if they actually were involved in the design of the product, then they would not be exempt from it. If they participated in either the design or the of the product, then they're going to be liable. But you also, in addition, have the products and the part manufacturers, you have distributors. And so distributors are generally held liable for the defects in the products they sell, but they're not necessarily liable for hidden defects if they did not contribute to the defect or the manufacturing process. So if it's something that they're not liable for some defect that they didn't contribute to or that they were involved in the manufacturing. Wholesalers are real similar to distributors. They're treated almost the same. They have the same liability. They're held liable for defects in the products they sell, but they're not liable for hidden defects if they didn't contribute to the defect or the manufacturing process. So they didn't help design it. They didn't help manufacture it. They're just selling it as a wholesaler. They're only distributing it as a distributor. They didn't design it. They didn't manufacture it. Retailers may be held liable for defects, but they're not liable for defects if they didn't contribute to it and they didn't contribute to the design of it and they weren't involved in the manufacturing. Now remember our example that we talked about that retailers may be held liable. We talked about this on an earlier slide if the company is bankrupt or not subject to personal jurisdiction. Those are the instances in which a retailer may be held to a strict liability claim as if they were the manufacturer. So what about used goods? People sell used goods. People sell used cars. There's even places that sell used tires, for example. Sellers of used goods are usually, the general rule is they're not strictly liable for the defects because there's usually no warranties or expectations that come along with used goods. It goes right back to the Latin phrase of caveat emptor, which means let the buyer beware, that the buyer is assuming the risk that comes with the used goods. This is a transaction in which you buy something as is. You go to Best Buy, they're having an open box sale on a DVD player. You buy it. It is an as-is product. You're buying it at your own risk, and there's no warranty usually with those products. unless specifically told. But oftentimes when you buy those products, you don't get the benefit of any warranty. Those being used products, the seller would not be strictly liable for a defect because it's a used good. Now, on the flip side of that, if the seller actually repaired any defective product or performed any work on it, then they would be liable for any defective repairs or defective work that they did. And that makes sense. In the other sense, they're only selling a used good that they didn't have any hand in or involvement in making it defective or unreasonably dangerous. But if you do take steps and you repair something or you replace something or you just do some general work on it and you customize it or whatever it may be, then you could be liable for the defective, unreasonably dangerous condition that would result from your work. So in this chain of distribution, you can see how it goes from manufacturer to distributor to a wholesaler, ultimately to the retailer. You've got all this uh, involvement in pieces and companies that work together in this chain of distribution. Um, how do they protect themselves against liability? Well, you may think a disclaimer. They disclaim any liability, but that's usually going to be unenforceable. But what the parties can do is have indemnity agreements. An indemnity agreement is an agreement in which one party agrees to reimburse the other party for liability that the party may incur for defects that's caused by the other party in the distribution chain. So you're protecting, the manufacturer is telling the wholesaler or the distributor that I'll protect you, I'll indemnify you against any claims you have for a defective or unreasonably dangerous product. So here's the example. Acme Manufacturing has an indemnity agreement with the retailer Seaco for the selling of life jackets. So Acme Manufacturing makes the life jackets, Seaco sells them, and there's an indemnity agreement between them. So if the life jackets are deemed defective in a lawsuit and Seaco is found to be liable for $100,000, then under their indemnity agreement, like Acme Manufacturing is responsible to reimburse Seaco for the $100,000 judgment that they incurred. So we've looked at the potential ways in which a manufacturer or a seller may be liable for unreasonable or defective conditions of products. So it looks like they're just in a bad spot, but there are a number of defenses that a manufacturer or seller may have to a product's liability claim. And here we'll briefly go through a few of those. The assumption of risk. We talked about it just a moment ago. Basically, when the user voluntarily and unreasonably assumes the risk of a known danger, the manufacturer is not liable for that injury. This was the example of the medication. So if you've adequately warned and told them of the risks associated with the medicine, but they still go ahead and assume that known risk because they take the medicine and it does cause some injury, even though if it's a remote one, but if it does cause it, then the manufacturer or the seller would not be liable because the buyer, the user, knew of the risk associated with the medicine, but yet they made a conscious decision to take the medicine despite the risk. They made an informed decision. When they assume the risk in that scenario, there's not going to be liability for the seller or the manufacturer. We also talked about comparative fault when we talk about it in the negligence context. And so if you have a claim based on negligence, so it's a non-strict liability claim, then you have some angle that you may argue comparative fault. Now, comparative fault comes up in the strict liability sense. It may not be seen or labeled the term as comparative fault, but you can see it in that we talked about ways in which you can argue that they used a product beyond its intended use. It was not foreseeable. And so to a degree, you're shifting a claim over to improper use, meaning that they're in part the cause for the harm they suffered. They were improperly using the product. And so that implies a degree of comparative fault. And so while it's not in the specific terms of comparative fault, you can see how the comparative fault principles are influenced into the product's liability claims. Another defense is the obvious risk, and we've already done an example of this. But if the product has an obvious risk, the manufacturer is not held liable for injuries that's caused by you ignoring that obvious risk. The example we did earlier is the gun. An obvious risk with a gun is that if you shoot yourself, you're going to injure yourself. Manufacturer is not going to be held liable for the user's failure to observe that obvious risk and not shoot themselves. A sophisticated user is another defense. So if you fail to warn somebody, then the claim is going to fail if the user is sophisticated enough that he or she should have known the risk or the harm. And so these are where you have almost, I don't want to use the term expert, but it's somebody that has extra knowledge or skill about the product. And if they're that person to where that skill, they should know, or they in fact actually know of the risk, then they're not going to have a failure to warn claim because they should have known. And they can't say, well, I mean, this makes sense. If you know something, but you try to claim that they didn't warn you about something that you already knew about, it doesn't make sense to impose liability on a manufacturer or seller because they didn't tell you something that you already knew. The sophisticated user is based on an objective standard for determining knowledge. What a sophisticated user should generally know, not what that particular user knew. Another defense is an unforeseeable misuse of the product. So the manufacturer or seller is not held liable for an unforeseeable abnormal use of the product. We talked about an example of this earlier where you have the manufacturer or seller sell a gun. The user of it takes it and tries to convert the gun into a potato gun. That's an unforeseeable abnormal use of the product. The injury that occurs is because of, goes back, we talked about comparative fault just a couple of seconds ago. That's essentially akin to a comparative fault type argument, is that your unforeseeable abnormal misuse of the product. Another one that you have come up is preemption, and this is most common in the medical or pharmaceutical industry. And so preemption, if you'll recall from some of our earlier weeks, we talked about how federal law trumps state law. So if there's deemed a conflict between federal law and state law, federal law is the law that prevails. It's the supremacy clause in the Constitution. And you may have where the federal government has enacted laws or regulations that set a minimum safety standard. And so these minimum safety standards under the preemption doctrine may preempt the state law products liability claim. If that's the case, then it's because these minimum standards were met, then there would be no product liability claim under state law because in a sense, if you think about it, you have federal law saying if you meet these minimum requirements, then the product should be safe. But then in a product's liability case, you're basically saying the product is unreasonably dangerous or defective. And so the federal government saying one standard, and then the state laws declaring that to be dangerous or defective. And so the argument is that they're in conflict then, and because of preemption, the federal statutes would prevail, and you would not have a claim for state law products liability. So now this defense is not absolute. There can be times when you can say that the federal statutes and regulations were not stringent enough, or they were vague or general guidelines, and were not sufficient to set a minimum standard such that there would be a conflict between state product liability law and the federal regulations or statutes. And so the more strict that the federal standards are, the more likely that you have a preemption defense. So the last topic to cover is successor liability. We talked a little bit about successor liability in an earlier session. And so when we say successor liability, we're talking about the liability that a buyer of a former company may have. So let's use the example here of Delta Company buys Acme Manufacturing. So we're talking about what liability does Delta Company have for Acme Manufacturing. So if you have the example here of after Delta buys Acme, 2 years later, a product's liability claim exists because of the defective life jackets that Acme Manufacturing made. Well, technically, Acme Manufacturing is no longer around. So the user of the life jacket, can they sue Delta Company? That becomes the question. Under the successor liability, the general rule is that to be liable, for Delta Co. to be liable for Acme Manufacturing's products liability claim or any debts that um, Acme Manufacturing may have owed, Delta Company, one of these four has to be met. So either Delta Company has to have expressly or implicitly agreed to assume Acme Manufacturing's liabilities or debts, or Delta Company, the transaction of buying it, must have amounted to basically a consolidation or merger of the companies to where essentially Acme Manufacturing still exists, it's just now the name Delta Company. And so if there's a consolidation or a merger between the two companies, then in that scenario, Delta Co. would be absorbing the potential products liability claim and the debts of Acme Manufacturing. Also, if Delta Co. is just a mere continuation of Acme Manufacturing, that could be a basis in which Delta would be liable for the product's liability claim or the potential debts. So in the continuing entity theory, this is basically the thought that there's really little change between Delta and Acme. So it's almost like a name change. Delta is now the name, but the seller's location is the same, the employees are the same, the shareholders and the directors remain the same. It's a very small change. So if it's a mere continuation of what Acme Manufacturing was doing before, so if Delta Co. buys them, they still manufacture the life jackets at the same place, the same workers still are there and all of that, then it's a mere continuation of Acme Manufacturing. And in that scenario, Delta Co. would be liable for the product's liability claim. And lastly, there would be liability if the transaction, if Delta Co. buying Acme Manufacturing was essentially a sham designed to avoid this liability. And so to determine that it's a sham would be a very facts, circumstances-based decision. You would have to do a lot of digging to find evidence to support that the only reason for Delta to buy Acme Manufacturing was to avoid the liability that Acme Manufacturing may have. So we've talked about products liability, and as you can see, products liability has the potential to just be an enormous claim, like we talked about with the manufacturing defects. If you have a manufacturing defect, you may have one up to thousands of the products that are defective because of some problem during the manufacturing, some flaw that happened during the manufacturing. So you could be subject to a large number of products liability claims. The risk is even greater for a class action lawsuit if you have a design defect. And a design defect, in theory, every unit produced would be defective. And so you would be subject to every unit produced and sold. You have the potential for a products liability claim. So I say that point to make that products liability litigation is a large area, and there may not be a ton of these cases that come around, but when you get a case, it's a very big case, a very time-intensive case as a lawyer to work on. And so for the business side, if a products liability action happens, it's something that's of great importance and could be a great liability to the company. The company could be subject to multiples of hundreds or thousands of claims of liability, and it could be a very damaging claim in that each claim is worth thousands upon thousands of dollars, or may be minor claims, but it could become very expensive and costly to the company, and it could be a threat that could, depending on the size of the company, could pose a threat of basically causing a failure of the company. If you have a product that is horribly bad and you've got the potential for large liability for all the items that are produced and that are on the market, a business could be devastated, if not driven to bankruptcy, and ultimately closed because of products liability.